Hello, good evening everybody. Welcome to the West Goshen Township Board of Supervisors meeting for December the 2nd, 2025. To start the meeting, will you please stand and join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Please be aware that this meeting is being live streamed on YouTube, and the meeting may also be audio or video recorded by people present in the room. Our first item of business is the opportunity for public comment. Is there anybody here who has a comment or a question for staff or the board about an item that is not on the agenda this evening? Doug. Doug, I don't know if the microphone's on, but if you could turn it on if it isn't. Should be on, okay.
Test 1, 2, it's on. Thank you, good evening. Just a couple of comments and some questions regarding the former Barker property, 905 West Town Road. The name Forsyth Farm has been given to this property. Where did that name come from? Is that an official court or historical name in it's documented somewhere? The name Forsyth Farm.
Who's the question directed to?
To your group.
Oh, to our group?
Yeah.
Your question should be directed to the board.
Okay, well, does the board know where the name came from?
I do not.
Okay.
Well, I
Okay.
just want to say, my understanding is that originally the house was built for someone by the name of John Forson, so that's where the name came from.
Okay, I was just wondering if it was an official name. As far as the historical assertions and claims, has been any documentation been given to the board about those claims? In terms of the, other than who lived there and how old it is, the historical implications to the community, has any documentation been provided to the board?
Not documentation, but we have received emails from residents expressing their views as to the history of the property, etc.
Okay, to the views, okay. As far as the land development that could occur there and options for open space preservation, to my knowledge or to the board's knowledge, I don't think any land development has been proposed there. And my opinion is that Mr. Kravitz has every right to develop it as the zoning ordinance sees fit, and that the residents concerned can certainly come to planning commission meetings and voice their input about that. As far as the township, whether or not they should purchase the property, I'm in agreement that they not purchase the property outright. As far as other options for open space preservation, such as open space easements or TDR, transferable developmental rights, that would be a board decision. And they would entail agreement with Mr. Kravitz. And my opinion on, well, this is directed to the board, but any private individual or group should be interested in purchasing the property. And as far as, I guess, and we've been hearing a lot about this, and I'm just voicing my concerns. I would like there to be more positive energy directed towards Mr. Kravitz. I don't, wait a minute, let me talk.
Yeah, please, don't interrupt the
Please.
speaker.
Mr. Kravitz is not this boogeyman that he's portrayed to be. He was gracious enough to allow Michael Piligali, Chair for Historical Commission, to come onto the property, document it as best he could. He was not allowed to go inside, but he's been very gracious to Michael. And to my knowledge, Mr. Kravitz does build homes, and he provides homes for people to live. Now, what's happening with that property is between Mr. Kravitz and the township, and you'll work it out, however you do. So I would encourage anybody who is interested in that property to be nice about it and to work with Mr. Kravitz so that their goals can be obtained. As far as the people living on Falcon Lane,
I'm sorry, what did you say?
as far as the people living on Falcon Lane, I know it's they're near that property. I grew up on Falcon Lane too, before the cut through was made. And that whole property was formerly the Barker property. It was all historic. Falcon Crest, there was a very historic farmhouse that was on the corner of the Pike and Falcon Lane that was torn down in the 80s. The whole area is very historic in a broad sense. So I think anyone concerned about that property should take a big view of it. Land development isn't all bad. Without land development, we wouldn't have this beautiful space to live in and the low taxes that we all enjoy. We can guide the land development and make it nice. And that's what we try to do on the Planning Commission. That's what the board tries to do. I think that that's all I have to say. I appreciate people's passion about this subject, but passion and being dramatic about it is not the same thing as practical solutions and really proving what you're saying. And if there are real documentation available for all the historical aspects, please bring it forward. Thank you very much.
Okay, thank you, Doug. Chris, I think it might be appropriate, just so everyone's on the same page now, in terms of where we are with the process with the conservator and the information you've received from the conservator relatively recently. If you could just inform everybody present about the status of 905 West Town Road.
Yes, absolutely, Mr. Chairman. So we did have the conservator go out there and start looking at the property. The structural engineer has been out there. We have not received any kind of a report related to it, but the building has been resecured. We anticipate engineering assessments to be completed for the building and the bridge, with those expected, I would say, within the next week. We're waiting on a load rating for the bridge in order for safe transport of the fencing to secure the site. We have installed no trespassing signs on the foot of the driveway, and we are going to install a locked gate on the foot of the driveway. It was discovered that the property may have been used for hunting. I believe they found like baiting, like instruments for baiting on the property for baiting deer. But we are actively moving forward with getting reports from the engineers on the status of the bridge and the building.
Okay.
And each individual building will be secured with fencing.
Right. So the conservator is driving ahead with the process. The immediate board's concern about the public safety issues associated with these structures and open pits is being addressed with the fencing.
Correct.
The studies are being done relative to the capability of the bridge to hold vehicles, etc., and also a structural assessment of the property itself. All this will be used by the conservator to inform the township and the legal process with the judge. The hearing's already been scheduled for March.
Sometime in March.
Yes. March 16th. So,
and then we should have those, like I said, we should have those reports in the next week.
and we've said that any official report or documentation reports that we get from the conservator will be posted on the township website.
That's correct, Mr. Chairman.
All right, thank you.
So just to clarify then, the next step legally in this whole process is the March 16th hearing, at which point the conservator will present a final plan to the judge,
That is my understanding.
and the judge will make a decision as to what will be done.
That is my understanding.
Okay?
Okay, thanks. Anyone else with a public comment? Mr. Rabari?
Thank you, Mr. Chairman. My name is Abbas Rabari. I'm a taxpayer of West Goshen. I'm a full-time corruption investigator. I investigate corruptions in the police department and municipalities, and I report those findings to the proper authorities. A few years ago, I investigated the West Goshen Police Department, and I discovered they are not 501c. All those little cards you get, please give money to Police Officers Association, they were not 501c. And they were taking this money without declaring it to IRS and spending it. After that, my team and I, we reported that to the proper authorities in Harrisburg. They were fined $6,000 and they were ordered cease and desist order. This is a fact, it's not allegation. These are proven in the court. After that, my investigation, I looked into there's a drug box located in the police department. If you have unused medication, you can put that in there and they get rid of it for you. The individual in charge of that is Detective Sergeant David Maurer. Detective Sergeant David Maurer was stealing these drugs and utilizing it for his personal use and prostitution, getting basically sexual favors. I don't want to get too graphic. You can use your imagination. Last week I attended the hearing before Judge Black, and he pleaded guilty, and there was 2 counts in there, and he was given a fine and get well, basically. And last year, he declared he took $200,000 of your tax money. This guy was stealing drugs while he's doing his job. He received $200,000. I did a FOIA request, that's Freedom of Information request, and I obtained those information through a police department. And after that, just so you know, I was a target. I had a target on my back. So the police came. I was renovating my ex-wife's home and to sell. She's retired. We have 2 kids. My daughter is a surgeon. My son's a sound engineer. Everybody's out of the house. We were selling the house. Detective Maurer targeted me because I was focused on him investigating. They arrested me. 3 years of legal nightmare, which resulted in my having a heart attack, blind eye, lose a kidney, stone, all kind of medical problem as a result of stress. But anyway, I prevailed, and I'm in front of it now. And after that, you have to ask yourself what kind of corruption exists in this township before. My father was a Superior Court judge in Iran, and we were a little kid. He used to always say, corruption starts from the top. So remember, corruption starts from the top, not from the bottom, from the top. So in that corruption, you have to ask yourself why this township has a new township manager, new zoning officer, new engineer, new public works, head of the public works. It was so bad, the head of the public works, he hung himself from the tree, and he has a little daughter this tall. So you have to ask yourself, what is going on here? Why nobody talks about it? Why somebody like me have to come here? Why somebody like me being told they're gonna kill you? That's why I wear a bulletproof vest. That's why I carry a camera. That's why every action that I do, I fear for my safety. So that is the problem. When I started investigating the police, they did everything they can do to prevent me getting information. That's under Freedom of Information Act. By the way, I'm not new to this. Your solicitor knows me very well. I've been around the block. I know how to function within a system. So I'm retired right now. I've dedicated my life to clean up this police department. This police department is corrupt. Maurer was not the only one. There are other actors in here, and your chief of police is hiding it. Your chief of police is the biggest crook that you can find. Now, I learned a new word today, nepotism. I had to look it up, nepotism. His dad was a chief of police. He's a chief of police now. Can we find somebody else? There's a thing in the police business, it's called thin blue line, blue wall of silence.
Mr. Rabari, you've had over 3 minutes, which is our normal time for speakers to present.
I didn't know there was a limit.
Okay, so this isn't
The
necessarily.
last guy, excuse me,
If you just finish your thought and finish your sentence, and we'll move on.
I understand. The last guy, the last meeting I was here, he stood here 28 minutes talk. You never said anything. Do you have something
So
against me?
it's at the board's
Do
discretion.
you have something against me? Because I'm pointing at you, you're the biggest crook. You were in charge of all this nonsense.
Mr. Rivera, you're out of line, sir.
I'm out of the line?
You are out of
It's a
line.
free speech, it's called free. There's a police officer in there, arrest me so I can
You had
sue
your
you.
opportunity to speak. and
Arrest me so I can sue you.
Overdone.
Yeah.
This is exactly
Public
what's
comment
going
is
on.
not a
You are
soapbox for
afraid,
your allegations.
allegation, it was proven in front of Judge Black.
You've also made other claims that we have no evidence that it.
Oh, you have no evidence?
So for example, you claim you're a taxpayer of West Goshen. What taxes do you pay to West Goshen? You're a property owner in West Goshen?
I have a 511 Cork Circle.
You-
I brought the document to you, showed you
You
the,
did not show me a document.
you didn't want to look at
Your
it.
wife is the property
My
owner.
wife is the owner. You have a problem with that.
So you're not a
I am
taxpayer of
renting
West
that
Goshen.
place because that way I pay, who's
All right.
it? Ask your tax guy.
Finish your thought.
Why are you so
Just
afraid
say
of me?
it.
Why
I'm
do you
not
want to
afraid
cut
of
me
you at
off?
all, sir.
You're fearful.
I'm not afraid.
As
of
an
you.
immigrant, you should be ashamed as an immigrant. You are an immigrant like me. You should be ashamed of that. You
I'm
want to
gonna
shut
ask
me
you, I'm going
off.
to give you one more minute to finish what you wanted to say when you came. If you don't, relinquish the microphone, I'm going to ask an officer to remove you.
Ask the officer to move me right now.
I'm giving you a chance to be reasonable and respectful.
I have a right to speak.
And we've given you that right.
But why are you cutting me off?
Because there's a time limit.
What's the time limit? 3 minutes?
3 minutes.
How come the last guy was here?
Because it's the discretion of the board.
Oh, discretion of the board.
Because you're not making a comment that we can act on tonight or do anything about.
I see. I see.
Okay, so finish your thought and then sit down, please.
Okay. So that's what the corruption starts. I'm investigating the corruption. Your township manager knows I have done a lot of FOIA requests. I'm not going away. Let me explain something to you. I'm not afraid of the police. If they make a mistake, U.S. Code 42, Section 1983, deprivation of right under the color of the law. First Amendment, Fourth Amendment, and 14th Amendment violation. Ask your solicitor to explain that to you. Thank you.
Thank you. Is there anyone else with a public comment? Yes, sir.
Okay. May I approach?
You may.
Thank you. I am limiting myself to 3 minutes. I've practiced. So,
What's your name, please?
Bill Aronson, Dr. Bill Aronson. I am a 40-year resident at 892 Bobolink Lane, and the house at 905 is, you can see it clearly from my front porch, the second closest house to it. I wanted to kind of talk to the board because I don't feel I've had the opportunity till now. I see myself as an amateur historian, and in answer to the question about documents, Quakers are meticulous in record keeping. So I can tell you as a Quaker descendant that I know about my family because of that type of documentation. That being said, and I know that I'm just probably, hopefully, preaching to the choir, that the Forsyth House is one of just really a small number of historic properties left. Yes, the whole region is historic. I understand that. I've lived here for 40 years, and my entire adult life has been in Chester County. So, but I think we have to look at the opportunity to view this house as a place where we can reflect on and look at Quaker history. I think it's critically important because it was a driver of our Declaration of Independence, driver of the Constitution, and it all started with Penn's Holy Experiment. Where did it go from there? And this house is pivotal to almost everything related to Quaker history in this region. There are a lot of connections that I think we need to make and we need to think about. Unfortunately, because the last 23 years, as wonderful as Mr. Kravitz may have been to you, as a neighbor, not particularly, because he let that place go to rot. And it's really unfortunate. And in terms of plans, I actually saw his plans in detail. I happened to be out there when, in my cul-de-sac when he went over the plans. So, now, conservatorship. I'm a professor at Temple University, and I can tell you in terms of historic preservation, I've seen two critical projects that that the Historical Commission would not allow the university to tear down properties. One was the Baptist Temple itself, which is kind of infamous. At any rate, I know that anything is possible, okay? I'm really concerned about two things. One is in terms of the conservatorship. A lot of conservatorships are concerned about community members. I would really like to have an opportunity to work with them, to talk to them. I'm a neighbor. I'm right next to the property itself. Whatever goes on that property is going to have a direct impact on me and my family and my neighbors. I have one particular concern that I'd like to raise, other than the conservatorship itself. As I said, I would like to have the opportunity, and I know my neighbors would, to have at least some discussions about what the observations are. I was quite surprised about there being hunting on the property because I've never heard anything unless it fell an arrow. So, at any rate,
I believe I said there was evidence of hunting.
No, that's what I said. The evidence of hunting, which I think is interesting. It could be there from years ago too.
They didn't indicate how long it had been.
Mm-hmm. Okay. One of the things I'm concerned about in any proposals for development is the marsh at the lower third of the property. I'm concerned about that. Forsyth Run goes through my yard, And I can tell you the flooding over the 40 years that I've been there have been numerous times where that little tiny little creek becomes a raging river. I mean, a raging river, and it's come almost up to my house multiple times. My concern is that in terms of land conservation, that the marsh needs to be protected, because marshes tend to be a place where flooding is actually absorbed, and there's a place for the water to continue to run.
So I hate to interrupt you on this. Obviously, you've done a lot of work on it, but we're not in a development phase.
Okay.
These issues are really more applicable to development.
Well, as long as my thoughts, my concerns
They've been
are
raised
reported.
before, yeah.
So that's
Thank you.
but I'm raising that because my property is particularly concerned by it.
Understood.
Okay, and that's the reason I'm raising it here. So, I would like to feel more enfranchised, certainly by you as a board and by the conservatorship process. I have very deep education, a PhD, professor, and I would really like to have the opportunity to work more closely with you in collaboration to see what can be done for the property. I want to conclude basically with one thought, and this is a quote from H.L. Mencken, okay, and you probably heard it before. For every complex problem, there's an answer that is clear, simple, and wrong. I think if demolition is on the table, it's clear, it's simple, and it's wrong. And I will conclude with that, and just to put that on the record, that as a person who looks out on that house every day, that I see that as a cornerstone of our continued growth and development and understanding of ourselves as a people and the history of this region. Thank you.
Thank you for coming. Is there anyone else for the public comment this evening? Stephen?
Good afternoon, good evening, Board of Supervisors. My first question is, who is responsible for conducting investigations into a developer who has a 351-page document that was filed that includes multiple judgments, multiple litigations against other homeowners in other townships operating in multiple counties, an individual who drives 2 Mercedes-Benz and claims he cannot maintain 905 West Town Road. I take exception to the fact that Mr. Kravitz is reasonable and willing to talk. He has destroyed 207 years of history in this township, dating back to 1704, one of the oldest townships in the country. It does not have one historic asset. This is a difficult problem for all of us. It's not just me versus you, us versus you. This is really something we need to seriously consider. And there are other townships that have found creative ways. We have a positive relationship with North American Land Trust, and we would like to ask the board to meet with our group, Save Forsyth Farm, to consider the options that are available within a 4-mile radius, and I'll wrap my comments up here, within a 4-mile radius of Shiloh AME Church and Cemetery, half-acre of hollowed ground that holds 14 United States colored troops, upwards of 140 graves. Isaac J. Winters, Pennsylvania 43rd, Company F, was the sexton for 68 years. He loved that church. The Winters families had close relationships to the Forsyths. This is a picture of major abolition history connected to the Rustons, potentially Harriet Tubman, who operated in Delaware County. And it's extraordinary. We should do everything we can to save it. Thank you.
Thank you for your comments, Stephen. Is there anyone else with a question or comment? Yes, ma'am.
I'm Brittany Schutza. Chris, I emailed you last week and asked for a meeting, and it was declined because all the decisions have been deferred to the conservator. So I'm just puzzled because we've been showing up here week after week, month after month, and the conservatorship was selected knowingly that we wouldn't be able to have any say or involvement.
That's not accurate. Your statements aren't accurate.
Okay, can you help me understand how it's not?
I said the board has made their decision. The board issued their decision. They voted to approve the conservatorship petition. There was over an hour of public comment on that conservatorship petition. Mr. Walsh read the plan verbatim. He read it out verbatim. We are going through that process. When there's information to share, there's information to share. I do not believe it is a valuable use of the township's resources for me to spend time meeting about something when it is going through a defined process that is the direction of the board. And I explained that to you twice.
Do you have any further comment? Okay, thank you.
If I could just might add, I mean, those who live within 1,000 feet, I believe it is, of that site have the opportunity to become a party to the conservatorship, but they had to meet certain requirements in order to do that. And the judge who's been handling this case, Judge Burway, decided that those conditions were not met. So as a result, you have to understand the township is not determining what's going to happen to this property. It's between the conservator, really it's the judge's decision to determine how to pay it forward.
Stephen, I'll give you the opportunity to respond if you have an issue.
Yeah, I can be quick.
Go ahead, please.
John, this is an extraordinary circumstance because 23 years of failure of oversight of a historic resource. We've seen what happened to the east wing of the White House. The public does have a vested interest, and we've petitioned the township that this is this unique situation in which the township should intervene to protect a historic asset of national importance.
Okay, thank you. Is there any other public comment? Doug, I know it's back and forth, so if it's a new issue you want to make or a new comment, that's fine. But if it's a repeat of what's already been said, let's move on.
I just wanted to respond.
Okay. So I have one other issue that was provided to the board via email from Ms. Margie Swart. She raised a question related to the board's preliminary budget, which included a proposed transfer of $2.25 million from the sewer reserve fund to the sewer authority. And she questioned whether this is spelled out within the current lease agreement between the township and the authority. We've just received this email today, so I've not had a chance to look at it. Chris, I'm sure you haven't either, but we can look into it. But the lease agreement is specific to, I believe, the requirement to ensure that the township is the grantor of the ultimate payer responsible for the authority's debt. So that's why there's a lease agreement. It's to do with the obligations of the authority, which are provided through the township. So we'll look into it in some detail, but I don't believe there's an issue here.
And just a basic overview, the bonds are secured by the full faith and credit of the township.
That's what I was trying to say. Thank you.
I apologize.
Well, thank you for getting the words for me. Appreciate it. All right, so we'll move on to agenda item number 4, which is zoning hearing board application. A discussion regarding zoning hearing board application number 18, 2025 for 106 Fairview Drive, seeking variances from sections 8413A3, 8413A4, and 8413A8 from the West Goshen Township zoning ordinance. I have Shelby down as introducing that. I believe we have somebody with us. Thank you, sir, for being here.
Yes, Mr. Chairman, this is Rob Jefferson from Unruh Turner Burger Freeze.
Welcome.
Thank you very much for having me. Thank you all. Yes, that is correct. My name is Rob Jefferson from Unruh Turner Burger Freeze. I'm here on behalf of Cottonhead LLC. Mr. Jennings could not make it here this evening, so I am fulfilling the obligation and subbing in. This is a variance application, and there are several sections, as have been noted. The subject property is 106 Fairview Drive. It's located in the R3 residential district of the township. The property measures approximately 21,000 square feet in area. The proposal is to subdivide the property into 2 lots. The existing property contains a single-family detached dwelling, along with other attendant improvements. The existing property has some non-conforming aspects to it as well. But the proposal is to subdivide it and construct a new single-family detached dwelling on the new proposed lot. The non-conforming aspect of the existing home includes lot frontage along with some other non-conformities, but that's something that will be addressed during the zoning hearing board. Additionally, the applicants are not responsible for the size and orientation of the property. After the proposed subdivision, Lot 1 will contain approximately 10,458 square feet, and Lot 2, the proposed lot, will contain 10,806 square feet. The reasoning behind this, I spoke with Victoria. Victoria is one of the members of the LLC, and currently the property is occupied by Victoria's mother-in-law. The idea is to move Victoria's mother-in-law into the new proposed dwelling. She also has young children who are trying to find housing, so that's the reasoning behind this request. As noted, there are several dimensional variances. Specifically, in this R3 district, the minimum lot area is approximately 18,000 square feet, and as noted, each lot will contain a little bit more than 10,000 square feet. The other section is that lot width at building line. It's currently zoned to have 100 feet at the lot width at minimum lot width at building line. What's proposed is 85 feet. And then finally, the building setback from the front yard setback would be approximately 30 feet, where 40 feet is otherwise required. I would note that it'll be further away from the front yard lot line than the existing dwelling, but just wanted to note that for the board. So what we're looking for here this evening, we will be going to the zoning hearing board in less than 2 weeks. We are looking for essentially no opposition to the subject application. And I'm here to answer any questions if you have any.
Thank you, Mr. Jefferson. This was discussed at the recent Planning Commission meeting, correct?
I believe so, but I was not there, yes.
Okay, so it's noted here in the information provided to the board that there was a vote 5-4 to recommend that the board remains neutral on this application. Presumably you do not have any knowledge about what the concerns were from the Planning Commission that resulted in such a vote.
I do not, but the recommendation to remain neutral would be consistent with what we're looking for.
Okay. Do you know if the property owners had approached Rolling Green Memorial Park to add to the size of the property by potentially purchasing a piece of land from them?
I do not know if they've had that discussion. I had a conversation with Victoria today. That was not discussed.
Do you know if the resident adjacent to the parcel where the new house will be built has been informed about the variance that's being requested, and are they objecting to it?
So that was specifically discussed this afternoon with Victoria. She said she has notified the neighbors, and nobody has specifically objected to the application and what's being proposed.
Okay.
The proposed subdivision here will result in smaller lot sizes, obviously. How do they compare to the other lot sizes in that neighborhood?
They're essentially very similar. In one of our exhibits that's attached to the application, we outlined some of the other lots that are located within the area, but it'll essentially be very, very similar in size to what is proposed.
Does it currently have public water and sewer?
Yes, that's
Property?
my understanding, yes.
Okay. Is there any stormwater engineering practices being proposed on this property?
So because this is a subdivision, it'll still have to go through that process, even though it's not considered a land development because it's just one dwelling. But it's not the end-all of this process because this is a subdivision. So I believe you're going to have to come back and deal with the stormwater management ordinance and go back to the Planning Commission for the subdivision aspect. So this is not over, even if the zoning hearing board grants the relief.
And just to enlighten for Mr. Chairman's question, Mr. Kolakowski and Mr. Helm were both in attendance at the Planning Commission meeting, and I believe they would be able to speak on any concerns that were raised by the Planning Commission.
The biggest concern the Planning Commission had was over the size of the lots, that they were making the lot, so much smaller, and they felt they were trying to wedge something in the lot by the layout. Do you agree, John, that was pretty much?
Yes, that was, but they're all pretty much similar to the other lot sizes that are there now. So I think that's the reason why I went to a majority voting 5 to be neutral and the other 4 were not so much. Let me ask you a question. The zoning hearing board is going to want to hear from you being the legal counsel. What is the hardship here? So how would you describe the hardship here that the applicant has?
So there's the technical legal standards for the hardship that will be discussed, and Mr. Jennings will be able to address that appropriately at the zoning hearing board. What we're trying to do, or what the hardship is growing and family relationships and trying to age in place and make sure that living accommodations are achieved in such a way that it promotes family development. So I think Mr. Jennings will be able to address that better during the zoning hearing board application. But largely, we're trying to focus on maintaining family relationships and the mother-in-law. So,
Should the zoning hearing board decline this application, do you think the applicant would be interested in an in-law suite addition to the existing property?
that was not discussed, so I don't know.
Okay. What size is the proposed new dwelling?
That has not been officially determined. I believe in the application there's a proposed footprint, but I don't believe I saw a total square foot.
Okay. Brian, are you aware if there was a square footage provided or not?
There's not a square footage indicated on the sketch plan.
All right, I don't have any other questions, so is the board finished with their questions? Okay. So what is the board's position with respect to this application at the zoning hearing board? Does anybody feel that we should object to it, or do we remain neutral?
I should be neutral. But the zoning board make a decision.
All right, so it sounds like you have to make a case to the zoning hearing board, and this board will remain neutral on your application.
Thank you very much.
Thank you for your time.
Thank you. Take care.
Okay, we'll move on to agenda item number 5, which is discussion and possible approval of the conditional use decision for the application by JAS Real Estate Holdings, Kia of Westchester. Kristen, would you mind
Sure.
introducing where we are with this one?
Right, so this is a conditional use application filed by JAS Real Estate Holdings, doing business as Kia of Westchester. The board held the hearing on this on November 10th, 2025. The applicant owns 3 separate parcels of property. They together contain 4.45 acres. They're at 3 different addresses: 326 West Town Road, 721 East Neal Street, and 739 East Neal Street. The applicant wants to consolidate those 3 parcels into one lot and develop a new 12,155 square foot building on one of the, will be one of the combined parcels, which will be used for servicing motor vehicles as part of the Kia Vehicle Sales and Service Agency, which is currently located at 326 West Town Road. They also propose to build a 525 square foot addition to an existing building that's currently located at 739 East Neals. And that building, after the addition is built, will be used for Kia for offices for, again, the dealership that's currently at 326 West Town Road. So the proposed decision, because there were no parties at the hearing, there was no need to do a formal findings of fact, conclusions of law, but the proposed motion for you would be to grant the conditional use. And the particular section is 84-96 F1. That allows a vehicular sales and service agency within the MPD multi-purpose district, subject to the following conditions. The development has to comply with all evidence and testimony provided at the hearing on November 10th. The turf pavers, if you recall, they were proposing to put some turf pavers in the area between the office building and the existing dealership. Those must be maintained in strict accordance with the manufacturer's requirements and specifications and any township or PADEP regulations and permits. Those maintenance obligations must be memorialized in the stormwater management best practices and conveyance, operation, and maintenance agreement. And there's a typo there, I need to get rid of that second management. So that agreement has to be recorded contemporaneously with the final plans. Any development requires these stormwater agreements to be recorded. I want to make sure that the maintenance notes are called out very clearly for these turf pavers in that document. And then the third one is there shall be no loading or unloading of vehicles from West Town Road or East Neal Street. All vehicle delivery, loading and unloading must occur within the boundaries of the applicant's property, which the applicant indicated at the hearing that they could comply with. So those would be the 3 conditions.
Very good. Any questions from the board? I have one question, Kristen. I don't know if this was considered testimony or not. During the discussion on November the 10th, there was talk of extending the water service line further along East Neal Street to be accessible by adjacent properties. Is that considered as part of the evidence and testimony, or is it just solely whatever private agreement is reached between those parties?
I mean, technically, if they said that that's part of what they were doing, I think we could hold them to that. I think if the board wanted to make it crystal clear and not have to search through the transcripts, if their applicant's counsel is here, Gina, do you believe they would accept that as a condition?
They would accept that as a condition.
So I would suggest that we make it crystal clear and have it be very well noted that they will be extending the water line down Neal Street. Is that correct?
Yes.
Is that,
Yeah.
okay.
And it was to the immediately adjacent property owner, correct?
Correct.
Yes. I just want to make it clear that it's not
All the way,
full
yes.
Neal's.
So is it coming from the intersection of Neal's and West Town to the edge of their property?
It was actually an extension from, I believe, close to the entrance off Neal Street to the property, to the Kia property, just a further extension along that same road.
And we could put something in there with a land development plan showing the extension of the water line to service the adjacent property at, I can probably figure out the address.
So as testified to by applicant shall extend the water line
On East Neal Street to
the adjacent property.
to the corner of the adjacent property. I believe that's where it was run to. Brian, do you remember if it was
I'm
any
aware of
further?
the plans right now.
Thank you.
And any other questions from the board?
No.
Do you want to, well, while we're looking it up, Steve, if you have a public comment?
Yes, I do. So does this mean that they're going to have to comply with the ordinance and put sidewalks and curbs in?
That hasn't been decided as part of this conditional use. That'll have to go through land development.
I'll go through that.
Land development. So the sidewalk issue is a land development issue. This is the use issue, which is zoning.
So it'll come up again when it goes through land development, through the planning commission, and back to the board for the detailed design.
Thank you.
Sean, they're tying into the water line here in your section.
Okay, so there is
and
West Town
extending
Road.
it down.
Okay, to the corner of the property of,
West Town, this is West Town.
yeah.
This is the connection point in the intersection.
And where's it shown going to?
Down.
Right, all the way to where though, because
It
that's.
doesn't show an end point on the plan.
Okay.
It's just large. I don't know how far they're extending it. It does not show on the plan how far. There's no detailed design on that. That would be worked out. The detailed design of it would be worked out with the applicant. Aqua has to sign off on it before the plan can be recorded.
Okay, so Chris, I don't know whether that leaves you and Gina in terms of specific language, but
Well-
the intention is just to record that it will be run down East Neal Street.
Yeah,
to
so
be
we want
available to the adjacent property owner.
To just the most adjacent property to the west.
That's all I'm looking for
Yeah.
in terms of this.
Okay, so that's what I think we should say. So that we're from the intersection of, I'm sorry, Ryan, there already is a water line starting at the intersection of West Town and Neal's?
They're connecting, plan is to connect at the water line that is in that intersection of West Town.
So that line that's shown there is not there going down East Neal's, that's a new water line?
Yes, the black line you see
Okay.
is the new one.
Okay, so there should be the extension from the connection at West Town Road to the property, the most adjacent property to the west on East Neal's.
And
That's-
it's 715 East Main Street.
Okay.
In accordance with all.
I don't think that necessarily needs to be spelled out because anything is going to be in accordance with
It's going to be land
Aqua.
development. It's just
So-
make sure it's intention is to run that line.
As Brian said, Aqua's going to have to, Aqua's going to have to sign off on anything before it can be recorded.
Okay. Okay, so with that additional requirement, I will make a motion to approve the What am I approving? The conditional use approval for JS Real Estate for the expansion of the Kia vehicle sales
Objection,
service.
violation of Sunshine Act, no public comment?
I'm making a motion, sir. Will you please sit down?
I'm just asking.
There's going to be a public comment. We finished the motion in a second. Thank you.
I'll second.
Thank you. Is there any board comments or questions on the motion? All right, is there any public comment or questions on the motion? Mr. Rabari, are you a taxpayer in West Goshen?
How do you know that?
I don't believe you are.
I am, I showed you the paper.
You have not shown me anything.
I'm going to make a comment.
Well, I'll let you do this. If you have a document, please bring it up and show it to the township manager and the solicitor.
I can make a comment?
No, we have a resolution from 2019 that does not permit non-residents or non-taxpayers to make comments on items of business of the township.
Sean, you should be ashamed of yourself. As an immigrant, this is not England. Remember that, this is America.
Okay, sit down, please.
Oh, yeah.
Is there any other public comment? All right, well, we'll take a vote. All in favor, say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0.
Thank you.
Thank you, Gina. All right, agenda item number 6 is discussion on possible authorization to advertise a proposed ordinance amendment to Chapter 66, Sewers and Sewage Disposal of the West Goshen Township Code of Ordinances. Again, if Kristen, you would remind the board where we are with this.
Sure, a second to switch on my paperwork. So at the last meeting, you had a conversation about this. This was something that Chris had suggested that the board consider as a sort of an extreme measure in the event that property owners who are connected to the township sewer system are continuing to not pay their sewer bills. As you know, our office works diligently with the township and the utility director to collect unpaid sewer and trash fees. This is specific to sewer. There is a state law, Pennsylvania state law, that allows second-class townships as well as any municipal entities as well as municipal authorities to follow a process to be able to shut somebody's water off in the event that sewer bills are not paid after notice and opportunity to be heard. So what we've done is we've prepared an amendment to Chapter 66 that would give the township, it's not mandatory, it's a discretionary remedy that you would be able to utilize if you saw fit for delinquent property owners. The notice requirements are spelled out in the ordinance, which amends Chapter 66, Section 66-30.d. You had asked for changes to be made since the last meeting. We wanted it to say, instead of being delinquent for 30 days, that you were delinquent for 3 consecutive quarters. So that change has been made in paragraph 1. And also in paragraph 5, we added, if requested, the township shall pay to the water utility the reasonable additional clerical and other expenses incurred by the water utility. And if requested, the township shall pay the water utility the cost. So under the statute, it does allow the water utility the ability to ask the township to pay for any lost revenues. Chris, I believe, has had conversation with Aqua's counsel who indicated they don't follow that and they don't make that request of the township.
And yeah, just to add on to what Kristen was saying, the conversation was that's in the statute and that's in their I believe they refer to it as a tariff that allows them to do it, but they don't impose that currently.
Okay.
So those were the changes. Those 2 sections of the ordinance have been changed since the last time you saw this. So if the board was comfortable wanting to move forward and adopt this, we would have to schedule a public hearing. We'd need 7 days to do an advertisement.
I had 2 things. In section 6630D2, if we do go through with this, I just thought we should add written notice, certified mail, and or electronic notice with receipt received, rather than just a written, some type of receipt that it was received, that the owner received documentation.
Yeah, which I'm fine with adding certified, but I do just want to caution you that now with the mail, we're finding it very difficult to get certified mail cards back. So a lot of, when we try our best, we can send it certified and regular, but oftentimes we're not getting the certified mail cards back.
I can tell you in my experience sending certified notices for like notices of violation, 9 times out of 10, the actual letter comes back as like unable to forward or unclaimed or anything like that. So you're spending about I believe it's $10.44 per certified notice, and it gets returned to us.
And Tina, you have to post it at the entrance of the property, so they are getting notice.
That was my second question. How are we doing that? Are we entering the property?
We're putting it on the front door.
On the front door?
I mean, I guess we're entering to get it on the front door.
And that's okay, to enter the property?
I think so,
I
yeah.
just didn't want to see any problems with entering.
I mean, if somebody
property.
stood at the edge of their lot and said, you don't have permission to come on my lot, then yes, we'd have to adhere to that, but otherwise I think we can post it on the front door. And there's other service processes under the rules of civil procedure that do allow posting. For example, there's been times, even on these liens, these sewer liens, we've had to seek alternative service, and the court has allowed us to post the property.
Okay, then I would change at the main entrance, and I would just say post it, or something generic, because right now it says the main entrance. Which
Yeah,
makes
I think that's statutory language though.
Okay.
So I'm happy to change it if it's not called out by the statute.
Yeah,
Okay.
that'd be fine, because I think that's too specific.
Okay, so Kristen, you're going to look into the language there about whether it could be different than the main entrance, but you believe that probably is the requirement?
Yeah, we would normally use that language unless it was required by
Yeah.
statute.
I guess the intention is it's not stuck around the back somewhere kind of thing, so it's obvious to the property owner.
I believe typically it has to be in like a conspicuous
Yeah.
Conspicuous location.
Conspicuous,
Yeah.
I'm sorry,
It just makes it
conspicuous
sound like we're
location.
going to put a post there, and we're going to enter the property. It's going to be on posts before you get to the property.
I mean, that's how we do zoning notices, we put it on a post on the lot. But I think the front door is somewhere where you're expecting them to walk into and see it.
Yeah.
If you posted, and Shelby, please correct me if I'm wrong, if we had to post like vacant properties, it's usually on the front door, correct?
Correct. When we post notice violations, we put them right to the front door.
Yeah, so maybe just say post, if we're allowed, post it to the property and take out where you're posting it, because that could vary. Because right now you're required to post it at the main entrance, if you can.
Sure,
Statute
we'll look at
allows
that,
it.
and we can
Yeah.
change that if, as long as the statute that authorizes this does not use that exact terminology, we'll change it.
Okay. That's it.
Any other questions from the board?
Yes.
Go ahead.
You have something?
Yeah, I did. I just want to reiterate that this is the last measure. We're giving people 9 months to come in and make arrangements with the township to pay their water bills. Sewer bills, I'm sorry. To pay their sewer bills. 9 months is more than enough time for somebody to come in to make those arrangements.
Thank you, Nick. John, you have questions?
Yeah, I just have questions and maybe some comments as well. I appreciate that statement because I certainly, if this does get passed, would agree with that. But let me ask you a clarification. So if an individual is paid up on an aqua bill, or a water bill, but they are delinquent for their sewer fee, whether it be currently or for maybe some prior time, then it is allowed then under this ordinance, or would be allowed, if we pass this ordinance, to shut off their water. Is that correct?
That's correct, and it's permitted
Well, if they're
by,
paid up on their aqua bill, and they're not paid up on the sewer bill, we're gonna have aqua shut off their water, even though they're paid up on it, right?
Yeah.
and the statute, there's a statute that allows for
I
that.
understand, there's a statute that allows that. Somehow it just doesn't seem like that would stand in court, but I assume there has been litigation on this in the past?
We did not, to be honest, we looked at the case law behind it. There's nobody challenged the authority of a municipality exercising its rights under the statute. We did not find any cases that did that. There were cases that dealt with whether there was sufficient notice given, and if you didn't follow the notice requirements in the statute, then it was deemed that the process that they followed was not lawful, but there has not been a case that we found that somebody challenged the actual statute saying that the statute was unlawful.
Okay, so it hasn't gone to litigation on that particular issue?
On that particular issue.
I do, the agreement that was discussed, the agreement that was presented at the last board meeting was the form agreement that Aqua has that they engage with any municipality who enters in with them. I think it's reasonable to assume that they wouldn't have some kind of like form agreement or a standard agreement that they would distribute if there had been challenges that had held up in court.
Well, when there are Pennsylvania Supreme Court or even a higher authority, U.S. Supreme Court, or even a district court for the Eastern District of PA, when there are cases that determine that Pennsylvania statutes that are in our statute books are deemed to be unconstitutional or unlawful, that is notated when we see the statutes. When you look up the statute, there'll be a notation about the court case declaring it to be unlawful. So we have not found that.
So there hasn't been a case before the court to determine whether this is legal, constitutional.
Right.
At this time.
That's correct.
Okay. My next question is this. We have a number of people who are delinquent within the township who own their sewer. I understand that we saw a list. What percentage of our residents would you say does this comprise? Are we talking about 50%, 20%? Can you give me some general idea what we're talking? How big of a problem is this?
So just looking at, and I'm not looking at it on residents, I'm looking at it on our utility accounts, because that's what it's based off of. It's roughly 5%.
5% of the property owners in the township are connected to public sewer.
Correct.
So 5% of the property owners at some point or another are delinquent in their past sewer fees, maybe not currently delinquent, or maybe not that.
Well, that's 5, as of the end of our last billing cycle, it is 5%.
Are delinquent.
Correct.
Currently delinquent. Now, could there be a situation where somebody is paid up on their sewer bill, but maybe they, a year ago, or 2 years ago, 5 years ago, were not paid up, so they were delinquent for a certain period of time?
John, let me just real quick. When they get paid, when you guys get a payment for sewer, they apply it to the last owed bill. So if you were delinquent in 2023 and you pay a bill tomorrow, it goes to pay off your 2023. It's a rolling balance.
Oh, I see.
They don't use it to pay this quarter, they use it to pay what was owed in 2023.
Okay. So the people who are delinquent are currently delinquent, based upon whatever period of time they did not pay their bill. Because I know situations where I looked at that list, there's neighbors on there who are delinquent, and it's because of a medical situation they run into. There could be other situations where people lost a job.
Let
me just finish.
I'm sorry.
And there could be situations where people, go through a divorce. Could be have some family problems going on there. There's a lot of stories I'm sure that are out there. I wish we could take that group of 5% we're talking, be able to slice that up for those who are truly being negligent, and those who, because of fault of life, were not able to make a payment at a particular time to make their sewer fee up to date. So I'm concerned about that.
We do that, John. I mean, I handle a lot of the phone calls because my name is on the letters that go out. So I take a lot of the phone calls. My paralegal takes a lot of phone calls. And we always say that West Goshen is very reasonable. And if you address it, acknowledge the debt, and make a plan, and stick to that plan, the township doesn't want to pursue legal action. The township ends up, it costs money and time. So it's to everybody's advantage if the property owner makes the phone call and says, I actually got 3 or 4 calls today. Hey, I really don't want to, because they get a lien and they don't understand that it's not like they have to respond in any way. I mean, they have to respond in terms of trying to pay it, but it's not like there's a court date set or anything like that. And I just say to them, look, this was to make sure that the township's rights are protected in case you sell the property. It puts everybody else in the world on notice that this debt is owed. And call the utility coordinator and tell her your situation and work out a payment plan that works for you. So that always happens.
Understood.
Oh.
So following,
Well, I was just going to say, one of the issues is, yes, they contact Kristen, and Kristen lets us know when those calls occur, but then a lot of times the customers or the property owners then don't follow through with contacting us and setting up a payment plan and then sticking to that payment plan. So the whole goal of this is not to shut people's water off. The goal of this is a tool for the township and to just get people to recognize the debt and set up a payment plan. As Kristen stated, we work with everybody to try and get them on something that is reasonable and manageable.
So my last question, point Ravina, you kind of led right into it. If someone is delinquent on their sewer bills, they will have a lien placed upon their property, will they not?
Correct.
So eventually the township will get paid. It's not like, well, the township will. It may take years. It may take a while, or it may take, who knows, maybe just a year. Who knows how long it would take before a property is put up for sale. But eventually the township does get compensated for its sewer fees that are not being paid or delinquent. I frankly have a problem with shutting somebody's water, especially if they're paid up on their water bill. I don't know. I just don't feel comfortable having that as a tool in the toolbox, even though it may not be utilized that often. And shouldn't be, quite frankly. So even if this does get passed by the township, I would hope that it would be very rarely used as a tool in order to get the payment made. But that's my own feelings, so I'm not going to support advertising this at this time.
Just to build on that last point from John, Chris, you actually have experience with an ordinance like this with your previous role as Malvern Borough Manager. And I believe you said at the last meeting that this was never needed to be utilized because when it got to that point, you were able to work with property owners to either pay up immediately or to get on a reasonable payment plan.
In my nearly 6 years there, I don't recall a situation where we ever shut somebody's water. We sent notices,
right.
But I don't recall ever shutting anyone's water off. We had a similar provision when I worked in Berks County, and there was only one instance where we turned off somebody's water.
Very good, thank you. So in practice, it is quite reasonable to be able to use this as a tool to help people get onto reasonable payment plans. Would you say that's a fair statement?
I would say that's a fair statement, yes.
There was one other question.
One other question.
Go ahead, Nate.
How much is currently outstanding?
Last I looked, about $350,000.
Any other questions, Nate? Margie Swartz submitted a question related to, again, the legal basis for this. She was specifically suggesting that where there is a sewer fee tied to a flat rate, i.e. not proportionate to the water, which several, I believe, several municipalities have arrangements where it's tied to the water, is that likely to survive a legal challenge? In other words, is there a difference between townships with a flat sewer fee and those with a bill related to the water consumption? Do you have any view on that, Kristen?
Yeah, after looking at that email, the statute doesn't specify that it only is an available tool to be used by municipalities that base their sewer rate based on water meter readings. It's available, and the Municipal Authorities Act allows a sewer provider to determine how they want to base the rate, and so it can be based on water usage or it can be a flat fee. And this statute does not differentiate between saying only those municipalities that charge sewer rates based on water usage are able to use this tool. That's not in the statute.
Very good. Thank you. Is there any, I'm going to offer the opportunity for public comment now before we see if the board's willing to make a motion. Doug, you have a comment? Would you mind coming up? It's just easier to hear you, for everybody.
Yes, Doug White, West Goshen. Does this arrangement take into account situations where they're connected to public sewer but have well water?
You wouldn't be able to do anything in those situations.
Okay. And then the next question is, aside from a lien, what other mechanism does the township have to fix this problem?
Well, right now it goes through the lien process. Once it reaches a certain point, Kristen, correct me if I'm wrong, there's an execution on the judgment, and then it goes through the sheriff's sale process.
Right.
And to be completely frank, once it reaches the sheriff's sale process, which can take a while to get through, we have had situations where people then come up with the money. So the whole goal again,
they cure it.
Yeah, and what happens is to take a lien, you file what's called a writ of sciri facias. You then take a judgment against the person and go through a writ of execution to sell their property. That ends up costing them $2,500 more at a minimum, which they then have to pay in addition to what they owed for sewer. So again, it's a policy decision for the board, but part of this is to make people realize the more you let it go, the more you're going to end up paying in late fees, interest calculations, and additional legal fees to try to collect it. So it behooves property owners to not just ignore the lien in the thought that, oh, is the township really going to do anything? I'll deal with it when I sell my property.
Okay. Has there been situations where a homeowner connected to the sewer attempts to prove true hardship and then still is doing?
I mean, if there were situations where someone had a true bona fide hardship, then we work with them. Like if there's some sort of medical issue, if there is bankruptcy, things of that nature. Like we can't really, correct me if I'm wrong, but we can't do anything if someone's like in active bankruptcy. So we cannot do anything for anyone that's in active bankruptcy. So the same would apply here.
Okay. I'm in agreement with John's statement where you have these groups of people that are in true need to one degree or another, and then you have those people out there that are just, well, I'm not paying this bill because of whatever. that can be a problem. But, thank you very much.
Thank you, Doug. Is there anyone else with a comment at this point?
Sean, would you
Your record would reflect that you're not allowing me to speak.
If you could prove to the staff on our solicitor that you are a resident
taxpayer
or a
resident.
taxpayer, if you can show the evidence to that, I will let you speak in the future.
meeting.
You didn't show me
Why are
anything,
you so
sir.
afraid of me?
I'm not afraid of you. Please
You're
sit
so
down.
afraid
You've had
of
your
me.
opportunity to make these statements.
By
Please
the
sit
way,
down.
Chapter 11 and Americans with Disability Act. Chapter 11 would stop all that. American with Disability Act, there's a statute there. Your attorney is very knowledgeable. She can research that.
Thank you. I will make a motion to authorize for advertisement the proposed amendment, ordinance amendment to Chapter 66, sewage and sewage disposal. Is there a second?
Second.
Thank you, Nate. Is there any public comment or questions about the motion? Very good, then we'll take a vote. All in favor say aye. Aye. Is there any opposition? The motion passes 3-1. Very good, we'll move on to the next item, which is
Bless you.
agenda item number 7. Continued discussion, possible approval of the 2026 to 2028 service contract with Good Fellowship Ambulance Company. So before the board this evening is the continued discussion regarding this proposed service contract with Good Fellowship Ambulance Company. The contract was previously reviewed by the board at the November 6, 2025 meeting. During that discussion, the board requested certain changes prior to considering approval. Specifically, the section discussing the municipal advisory board be revised. This is section 14 and it has been revised accordingly. So we reviewed this previously, board, section 14. I'm going to read it out so people can understand what it's changed to. Section 14, Municipal Advisory Board. The township has declined to join the Municipal Advisory Board at this time. If the township decides to become a member of the Municipal Advisory Board in the future, the township reserves the sole discretion to appoint a primary and an alternate member to the company's Municipal Advisory Board.
And Mr. Chairman, I'll just note, I apologize, I didn't mean to interrupt.
No, I'm fine.
I'll note that I drafted that language, we ran it by the solicitor, and then we sent it to Good Fellowship, and they were in agreement with what's drafted.
So all parties in terms of staff, solicitor, and Good Fellowship are on board. So does the board have any questions?
I had one question, and maybe Steve can help me with this. In section number 10, the request of mutual aid coverage. Right now, it says that if they need coverage, they go to the Chester County Department of Emergency Services. Because I know, say if GFAC needs help, they'll coordinate with Good Fellowship, or Goshen, I mean, they'll coordinate with Goshen and they reciprocate. So I guess my question is, do they need to be named in here also, like additional qualified companies? Or does it go directly to the dispatch, Chester County, and then they dispatch like a Goshen if GFAC needs help?
It goes directly to the county. The county handles the 911 center. The county handles the dispatch and coordination of mutual aid.
Okay, so if GFAC can't handle it, who will call Goshen? That will
The
be
county-
GFAC?
the county
The
911
will
center.
call. So everything is coordinated through one area?
The county is charged with handling all the 911 dispatch coordination.
Okay, so if one can't do it, they'll find somebody else that can do it?
Yep.
Okay.
Did I get that right, Steve? Thank you.
Okay, thank you.
I do want to make sure the board is aware under section 5, and Kristen, thank you for bringing this up. There was the concept for the offset of payments for independent living and nursing facilities. Kristen, as the solicitor for the borough, did look at this as well and recommended worked with GFAC on some changed language, so that has been modified, and it's mirrored in here from her work with the borough.
Yeah, I just thought when I read the language, it didn't make a lot of sense to me, so I had suggested it just reword it a little bit so it was more clear. He was using terms of, he was saying assessments and contributions, and I'm like, what's the difference between an assessment and a contribution? So then we just agreed upon this language, I think is a little bit more clear.
So Good Fellowship's on board with this?
Yes.
Okay, thank you.
And when Mr. Brogan was here at the last board meeting, he had mentioned payments from Westchester University to kind of maybe offset the contribution to the municipality. It has recently brought to my attention that the university has made the decision to pay the municipalities directly as opposed to paying Good Fellowship, and then we can record that as an offset for our expenditure in our accounting system. I have spoken with Julie Trick about that, so they're just going to get the numbers from Good Fellowship for each of the municipalities in their jurisdiction, where the university is in their jurisdiction, and issue payments directly to the municipality.
But
Okay.
does that money that you're getting from them have to then go
No.
against?
No, it will.
Do with it, will you take that money and then use it to pay GFAC?
No, we will use it, we'll pay GFAC, because I talked to our finance director about this. We'll pay GFAC what we're contractually obligated to
Which
pay.
is on a twice-a-year schedule.
Correct. And then once we get payment from the university, which I believe will probably be at the end of the year, we'll then record it as an offset to the expenditure in our accounting system.
On the same line item.
Correct.
And how would that amount be determined? Would GFAC determine what that cost would be per call?
GFAC will determine, we'll send the information to the university.
Okay.
And it'll be a rate per call covered to the university. I believe the first payment, the email that I got from Dr. Dietrich mentioned a payment of around, I believe it was like $3,900.
But there's no written agreement that obligates the university, that's just good faith on that part to make that contribution, is that correct?
Correct. And in my conversations with the university, they are becoming becoming much more community focused in their obligations, and so this is not the first time they have come to us wanting to make a payment for something to offset a cost incurred by the municipality.
Yeah, it actually, I was at the borough meeting where the university was making a presentation on college arms and what they're proposing to do there. And it was the same meeting that GFAC was doing their financial presentation. And so a lot of members of borough council were pointed and said, well, it's great that the university is here because you're seeing, because he broke down the number of calls to the university. I think it was very helpful for them to hear that and see that, and for them to witness firsthand how much the costs are rising. And as a result of that presentation, I think is what led to them making that commitment, I should say.
Very good. Any other questions or comments on the proposed contract? All right, I will make a motion to approve the 2026 to 2028 service contract with Good Fellowship Ambulance Company. Is there a second? Thank you, John. Is there any public comments or questions about the motion in the contract? Okay, then we'll take a vote. All in favor say aye.
Aye.
Aye. Is there any opposition? Hearing none, the motion passes 4-0. Agenda item number 8 is discussion and possible certification of qualifying volunteers for West Goshen Township's Volunteer Service Tax Credit Program pursuant to Chapter 74, Article 5 of the West Goshen Township Code of Ordinances. Chris.
Mr. Chairman, before the board this evening is certification of qualifying volunteers pursuant to the section of the Township Code that you just referenced. The agencies providing fire and EMS service to West Goshen Township have all provided certified lists to the township along with the appropriate documentation. I provided a list of all the qualifying volunteers for Westchester Fire Department, Goshen Fire Company, and Good Fellowship Ambulance Company. There are 2 policy determinations for the board's consideration this evening as part of this. Christopher O'Neill, who was a member of Goshen Fire Company, recently sold his home and moved out of the township. I did review some available records, and it appears that the sale occurred around mid-November. The real estate taxes for the property are $244.18. That was the face value. It's about $239 paid during the discount period. When a property is sold, the seller receives a prorated refund on the real estate taxes paid. And the question for the board is, should the tax rebate to Mr. O'Neill be the amount that he paid prior to his move, or reduced to the amount after any sort of refund at the time of sale, if the township has those records. I spoke to Grant Everhart, inquired to me about this before submitting his list, and I told him just to include Chris on there. He was an active volunteer for ever and for a good chunk for almost 11 months out of the year, and that it would be the board's consideration. The second policy determination is nearly every individual listed paid their 2025 real estate taxes during either the discount or face period. There were, however, some who paid during the penalty period. Under Pennsylvania law, a penalty is assessed when the tax liability is not paid within 4 months of the bill being issued. Act 172 bases the real estate tax credit on the municipal real estate tax liability, and an argument could be made that the penalty amount is not part of the tax liability. So the question before the board is to refund the penalty amount, essentially only refunding the face value. Both the township's ordinance and the resolution establishing the standards for the rebate are silent to this issue. This was something that was brought to my attention by our deputy tax collector.
Okay, thanks, Chris. So just so I'm clear, so the refunds that are provided by Keystone, is that correct?
No, the refunds on real estate taxes are provided by, this is, the second part specific to real estate taxes. We issue those back to the volunteers.
Based on what information? Do we know if they paid the discount amount, the face amount? You have that record?
We have those records.
And they'll reimburse for their actual real estate?
Correct.
Right.
So if they pay during the face period, they get the face period. If they pay during the discount, they get the discount amount.
Okay.
And in the past, like getting started to this, we only had so very few people that paid the penalty period. We didn't refund the penalty amount, but now the question has come, do we want to do this?
So this is my opinion. The intention here was to incentivize and help people through providing a credit for their real estate tax. It doesn't take away their responsibility to pay their real estate tax on time and not wait until the end of the year or whenever they decide they want to pay it. So my opinion is we should not be repaying penalties on the real estate tax. What do other board members think?
I agree.
I will tell you, I won't name anybody specifically. There are only 3 people. There are 3 on this list, and one of them still has not, to the best of my knowledge, still has not paid their real estate taxes.
So it's really not a big deal.
No, but I tend to agree with the chairman.
So just for clarification, so some individuals are getting paid face value, others are getting paid the discount amount?
Yes, because they paid that. The discount period is again under the state law that says that if you pay within the first, I believe it's the first 60 days, you get a discount.
Right.
And it's to
But that's why
incentive.
you refunded those, that amount?
Yes.
If they paid that?
Correct.
That only answers question 2 on here. You guys
Yeah,
still decide?
well, let's just see where we are with question 1 with this one. So I heard a couple of board members be in support of not refunding a penalty fee associated with late payment of the real estate. John, have you got an opinion on that?
No, I don't have really a problem. I think we should try to get rules established.
We should okay.
And I would suggest the rule being that we refund only the amount that's actually paid by the individual should be the amount they get as a form of a refund. Then
that doesn't answer
the question. Because they're paying the tax plus the penalty. So the question is, do you give them just the tax back?
I was getting to that.
Okay.
Because actually they're paying the penalty as part of what they're paying. It's part of, ends up being part of the tax. Well, let me ask another question. If they were paying the penalty for what they didn't pay the penalty, and it was carried on, would that be part of the lien that would be placed upon the property?
Yeah.
Yes, it would.
So it's actually part of the tax.
You can make an argument both ways.
I know you can, exactly, that's my point. That's where I was getting to. But I understand, Sean, you make a good point. We would incentivize folks to pay their bills and pay them preferably at the discount rate. So that being said, I think we should make a rule being that they should only be refunded the amount that they actually pay in taxes. But then when we get into a problem about the penalty.
Okay, so I'm hearing generally 4 members of the board are supportive of not paying the penalty that's assessed for late payment.
Right.
Okay, let's go back to number 1.
So, Mr. O'Neill.
Mr. O'Neill, yes, sorry. So again, using the same logic, the indication would be that we should reimburse Mr. O'Neill for those taxes actually incurred by him up to the point of sale of his property.
He would have been at the settlement table, he would have been paid from the date of settlement till December 31st. He got that money, so he's getting double. And again, we're not talking a lot of money. So it's not
But it's the principal one to be sold in the middle of the year or whatever else, right? But it's a different proration. So the principle is the same, that you should be reimbursed for those real estate taxes that you have paid that do not involve a penalty through the point of sale of your property if you're leaving the township. So does the board support that position?
Otherwise, you'd be getting double pay.
Double pay, that's right.
I believe the recording date that I saw was around November 13th was the sale date, I believe. So what we can do is we can prorate the refund up to November 13th.
Yeah, I hope Mr. O'Neill would work with you on if you need specific information on that.
Yeah, I can ask. I'm sure Chris would be amenable to showing us the settlement statement.
All right. So do we need to take a vote on this or not? Oh, we need to certify the qualifying volunteers, correct? Do you want me to include those decisions in the motion then as well?
I believe it would be appropriate. capture everything.
Okay, I'll give it a shot. So I'll make a motion to approve the list of qualifying volunteers for the West Goshen Township's Volunteer Service Tax Credit Program. And in addition, the board is authorizing only the repayment of proportionate property taxes paid in the event that a property is sold, and also that we will not repay any penalties assessed on late payment of the real estate tax. Is there a second?
Second.
Thank you, Nate. Is there any public comment or questions about the motion? Steve?
Yeah, just, Chris, this could be a loaded question, maybe, is the number going up or going down since last year?
In terms of the number of qualifying volunteers, I believe, just in looking at this, I believe for Westchester Fire Department, it's gone up. I believe with Goshen, it's gone down, and with GFAC, it's relatively consistent each time. I believe with Goshen looks a little smaller than before. So, admittedly, I did not go back and compare them.
And we're seeing an increase in volunteers numbers because of the stipend of the LoSAP that we're doing now. The fire department.
Just on the face of it, I would say Westchester looks larger than in the past.
Any other? Yeah. Go ahead, John.
Just for the record, can you explain what the tax rebate consists of for the earned income tax as well as for the real estate tax?
So the real estate tax rebate is, like we said, it's up to their tax liability, and they have to meet certain qualifications that were adopted by resolution for the board. Each of the chiefs certify that people meet those qualifications, and they provide forms saying that they certify to that. Then for the earned income tax credit, it is a $500 rebate that's taken off when they file their earned income tax return with Keystone every spring. What I do is I take a form with all the information for all the certified volunteers, put it on an Excel spreadsheet, upload it to Keystone, and then they use that. They input that data. They have that data when people file their tax returns.
Any other public comments or questions on the motion?
I think Westchester Fire was up at 8 or 9 according to the chief. They have 25 now. Goshen has 9 and King Fellowship has 4.
Joe, do you have a comment?
So you mentioned about, so if the volunteer pays their taxes and then you rebate that, you would like them to pay it on time, just like normal. But because they're volunteer, they meet the qualifications, they're going to get their taxes back. And that's this whole program. But if they pay late, they get a penalty. And so, but they're volunteer, they pay late, you get a penalty, but you're not going to get the penalty back. You get the taxes owed back, but not the penalty, correct?
Correct.
Okay.
Any other questions? Okay, then we'll take a vote. All in favor say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. Next on the agenda is item number 9, which is discussion and possible issuance of the notice of intent to award pursuant to Chapter 65 of the West Goshen Township Code of Ordinances for the family bathroom expansion project at West Goshen Community Park. Chris.
Mr. Chairman, before the board this evening are the bid results for the family bathroom expansion project in West Goshen Community Park. This project is part of the improvements for Community Park, and the township has secured $450,000 in grant funding to date to offset the cost of the proposed improvements. The bid results were open on November 18th. Due to the nature of the project, bids were issued for general construction and electrical contracts. We provided the bid tabulations from Christopher Peterson from Carroll Engineering. For this project, the township received 5 bids for the general construction contract, with bids ranging from $216,700 to $388,000. And for the electrical contract, the township received 3 bids ranging from $11,531 to $23,350. As such, the cumulative bids range from $228,231 to $411,350. The apparent low bidder for the general construction contract is BSS Contractors, LLC, and the apparent low bidder for the electrical contract is Lenai Electric Corporation. Pursuant to Chapter 65 of the Township's Code of Ordinances, which is our responsible contractors requirements, the Township will need to issue a notice of intent to award. This will initiate the review process outlined in the ordinance to ensure that the low bidders meet the requirements outlined in the ordinance. Pursuant to section 65.4, the notice of intent to award is conditioned on the issuance of a written contractor responsibility determination. And once the determination is completed, the contract will come back before the board for final award. I will note I'm not aware of anyone in the township having worked with BSS contractors in the past, so we will do our due diligence on them. We have worked with Lenai Electric on a number of projects in the past.
Brian, have you any experience with BSS?
Yes.
Would you like to share it?
They were the contractor in 2017 for the, when I worked for Cedarville when they did a project. And we had no issues with it.
Okay. Questions from the board?
I noticed for BSS that question number 8 was not answered. That question is, in the last 5 years, has your organization ever failed to substantially complete a project in a timely manner?
I'll make sure that we get some due diligence on that.
Thank you.
Okay, so you'll follow with Chris Peterson as he does his review with that specific point.
Absolutely.
Okay, thanks. Any other questions from the board?
Well, just a comment for Lenai Electric. I noticed on the summary of work-related injuries and witnesses, the OSHA's form 300A, they didn't have a lot of injuries, but they had a lot of days off from work. In 2023, they had 91 days off from work. 2022, they were 162 days off from work. And 2021, they had 24 days off from work. Just to be sure that they had to meet the OSHA requirements by the responsible contractor, and that is OSHA 30 for their foreman as well as OSHA 10 for their employees. Just a little concerned about the health record that they have, the injury rate.
You said that's OSHA 30 and OSHA 10?
Yes.
Is it injury record or is it days off? Is it clearly it was an injury day off or?
Well, it's how it's coded.
Okay, thank you.
Total number of days away from work, 162. Not a lot of injuries, but a lot of people were hurt, but they were apparently injuries were severe enough that they had 162 days off from work.
So another follow-up then, Chris? Note for that follow-up with Chris Peterson in the review.
Yes, I have here to verify OSHA 30 and OSHA 10.
Any other questions from the board? Is the board member willing to make the motion to issue the notice of intent to award pursuant to Chapter 65 of the West Goshen Township Code of Ordinances for the Family Bathroom Expansion Project to BSS and to Lenai Electric, BSS contractors? Okay, is there a second?
Second.
Thank you, Nat. Any comments or questions from the board on the motion? Okay, any public comments or questions? All right, then we'll take a vote. All in favor, say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. Agenda item number 10 is discussion and possible approval of a proposal from Carroll Engineering Corporation for due diligence soil and groundwater sampling for the Goose Creek floodplain restoration project. Chris, this has your name on it, if you would mind introducing it.
Yes, Mr. Chairman. So before the board this evening is a proposal from Carroll Engineering Corporation for due diligence, soil and groundwater sampling for the Goose Creek floodplain restoration project. For some background information, the board reviewed proposals from Land Studies and Carroll Engineering associated with projects in the Township Pollution Reduction Plan at the June 3rd meeting. At that meeting, the board authorized Land Studies to prepare feasibility studies for 2 project sites and to hold off on the due diligence work outlined by Carroll Engineering. Land Studies presented the results of the feasibility studies at the October 21st meeting. At the conclusion, it was determined that Carroll Engineering should update their proposal for the board's consideration. Carroll Engineering Corporation has prepared the attached proposal for the board's consideration. The proposal before the board is at a not-to-exceed fee of $20,445, which represents a $445 increase when compared to the original proposal discussed in June.
Thank you, Chris. Questions from the board?
I have one.
Go ahead, Nate.
How did Mr. Pellak's resume look? It says that it's included as an attachment, we didn't receive it.
I did not receive that either.
Yeah, that was one of my questions too. I had a few questions too. If we can get Chris to get back to us on EPA methodology 8260D is good for soil samples, but they're also recommending that for the groundwater samples. A kind of question that. I would probably do a EPA methodology 524.2 or 502.2. Or you can take the acronyms for this. GC/ECD, which is a gas chromatography with electron capture detector, which is highly sensitive method for compounds like TCE. So I would just recommend that. And then on the screen, on the site screening, they recommend using a PID. PID is usually for a volatile material. They probably want to use a trap mass spectrometry, which is a DSI-TMS. Would be the only things I would say.
Is a PID, do you think, something other than TCE? I mean, it's a general catch-all for...
It's a catch-all, but it's mainly for volatiles. It's not necessarily for TCE, which is more of a sinker and a heavier type of viscosity. So I don't know. The PID is going to pick something up in your screening, so you may miss something as a screening tool.
Okay.
A couple of questions. On the scope of services that Carol's proposing, you talked about 10 sites for soil sampling. And on this map there, I only see 8 soil sample locations. And my question...
John,
I
it's
know.
really hard to see, so that one is combined.
But that's combined soil sample?
Yeah.
So, all right, so the
There's
that would
two
be soil
orange.
sample and a piezometer location. Yeah. Very good. Now, did they coordinate that, or is that going to be sufficient for the project that's being proposed by Land Studies for that area? Does that cover what we need to do as far as any permit regulations or requirements?
I'll look to Brian for that.
When I requested the revised proposal from Chris Peterson, I asked him to coordinate the proposal with the land studies feasibility report, and they did that. This is the revised proposal came back based upon that request.
You say you looked at their report, you didn't talk to them though, right?
He was been in contact with them, so that, like, when there was emails going around for some communication regarding the feasibility studies, Chris, Ben, you, land studies, and myself were all in all the communications. So I asked him to coordinate with land studies. I don't know what that coordination meant. I left it up to Carol. I didn't make him get on a conference call with me and have a discussion about it.
Okay, as far as your knowledge is, the result of the locations was as a result of collaboration, discussion.
My understanding is yes.
Okay.
That's pretty well covered. I mean, the whole area, you've got upgrading, downgrading. I think it's sufficient.
Yeah, my only question relates to the depth at which the samples are being collected. So the proposal was to 2.5 feet average depth. I mean, in terms of a restoration project, I believe Land Studies said that that would be the kind of typical
average
depth. But in terms of making sure that the deeper depths that make up an average are also investigated, I'm thinking maybe 4 feet soil sample would be better. But
I did speak with Chris Peterson about that this morning, and when this is being sampled, Carol will be on site, and I got the impression that Land Studies may be there as well. The conversation may be on site about for the sampling and making sure the depth is appropriate for each sample location.
I mean, I don't know the overall gradient across this whole area, but maybe at one location 2.5 feet is fine, but at another location 4 foot depth.
And so they're going to be individually determined in the field when they're out there sampling. I got that clarification from Chris today when I spoke with him about this. They put 2.5 feet in their proposal because the land studies report said it's generally a 2.5 foot lower than the floodplain. So that's where they put a general 2.5 foot number to match the land studies language. But they're going to be individually dependent based upon where it is in the site.
Fair enough.
So the question, after Carol does this soil sampling and all that study, they'll get that report to the township. Now, Land Studies will review that report, I presume, and then make a determination whether or not we could proceed with the stream restoration project at that point?
We haven't engaged land studies past what they've done for the feasibility reports.
I think we would look at that. I think
We would look at
the
that.
township,
Township,
we would
and
look at
Chris,
it and we would
and
decide.
their
whether we
environmental
talk
group
to-
would
yes.
give us
Whether or not we
the,
can move forward?
yes, that's the idea of this sampling, is because they have the feasibility study that says this is what we want to do, this is how we do it. Carroll Engineering and their geologist, sorry, I was looking to see if I could find the original proposal. The original proposal, Chris had his, Adams, when I brought it to you the first time, it was attached to that proposal. I remember when that came forward, I was trying to find it quickly here.
I can find that circular.
Yes, so I know it was attached to that one. I didn't realize it was my fault, I didn't realize it was attached to this. The Carroll will evaluate it based upon the testing report will tell us in their report. This is my understanding, if this is feasible, if the report shows anything we need to worry about before we go forward with the next step, of just engaging land studies for the actual design. So land studies has fulfilled their contract we had with them for $17,500 approximately to do the 2 reports. And now the next step is to engage Carroll to do with their subcontractor for the auger machine to do the environmental testing that we requested.
It's unfortunate that we have to do this, but we need to do it before we proceed with any kind of disturbance. So based on Tina's specific comments, I'm hearing that we really need further consideration from Carroll on the proposal based on the revised testing methods that Tina says would be a better way
Can
forward.
you email those in to us?
Yeah.
So if you could provide those to Brian, and Brian, you could just work with Carol on looking at their proposal, and we can review this again at December 16th.
And they're welcome to challenge me on it too. I mean,
This is outside my area of expertise, that's why I went to Carol. So I'm not an environmental engineer, I don't.
You might want to talk to Chris yourself.
And I do know that Chris did not, Chris may have been, he's my point of contact, but he never took a proposal. His environmental group and his PG did with this. So Chris himself is not involved directly. He's not the one that came up with the testing protocol. Adam did.
Okay, well, if you
And Adam's a
wanna give me-
hydrogeologist.
If you want to give me Adam's phone number, I can call him direct.
I will speak with Chris tomorrow.
Okay, do that. Go through Chris and decide how the best way to handle it.
Put it on the
That
payroll,
way.
okay?
I will, meanwhile, I will email you what I just said.
Okay, so Chris, we're going to table that until the next meeting. Get that resolved.
It might be the first meeting in January, the next agenda is fairly
Pretty full.
crowded.
Hopefully this is a straightforward one, assuming Tina and the other person get on the same page.
We'll see
Right, Tina?
We'll see how it maps out.
All right, let's not discard it at this point. Next on the agenda is agenda item number 11, which is discussion and possible award of the bid for magnetite for the West Goshen Township wastewater treatment plant. Chris?
I'll keep this simple. There were no bids received on the rebidding. Township's Director of Wastewater Operations did issue a new bid pursuant to the second-class township code. The due date was November 21st. So since there were no bids, the township is able to utilize the vendor of its choice, and the current vendor is Evoqua, thank you, Water Technologies LLC.
Very good.
So there's no action required by the board.
Yep, thank you. So that's more an update. Okay, agenda item number 12 is discussion regarding a proposed sidewalk extension along Paley Pike into the borough of Westchester. And this is with the board. Okay, so let's have a look here. So, discussion this evening regarding a proposed sidewalk extension along Paley Pike. The proposed sidewalk would run west on the north side of Paley Pike between 815 Paley Pike and the existing sidewalk at the former Pet Boys. Chris Peterson from Carroll Engineering has prepared a cost estimate for the board's consideration for this project. This would be to prepare a sketch plan of the sidewalk layout, and the proposal was provided to the board as part of the meeting materials. And then additional information related to the project for the board's consideration. The township's 29 comprehensive plan outlines a sidewalk connection in this location in order to provide pedestrian access down to Westchester Borough. Maps from the comprehensive plan have also been provided for review. Unlike the Rosedale Avenue sidewalk project, which is in progress, All proposed work is in the right-of-way controlled by the PA Department of Transportation, PennDOT, and based on review of land development plans in this location, it appears that the right-of-way width is 60 feet. Doing a quick overview, additional right-of-way may be necessary to complete the installation, so that's something that would need to be evaluated. As the project is in the PennDOT right-of-way, it would require permitting from them. The township would need to follow PennDOT specifications for the sidewalk design and installation. And in speaking with Chris Peterson at Carroll Engineering and Brian, our township engineer, there will be a need to use retaining walls at the intersection of Paoli Pike and Garfield Avenue due to the gradient in that location. What questions does the board have?
I'll just make a comment. I know in this section along here, especially on the other side of the Pep Boys, there frequently when I drive past it, people have to walk in the street in the actual cartway because the slope from the cemetery to the road is so steep they can't walk along the grassy area. They actually end up walking in the roadway. So it really is a dangerous area, and for us to have a sidewalk installed there, I think would go a lot towards the safety of our residents and others in our community. That, and also just want to reiterate, it was something called the comprehensive plan, which the township adopted back in 2019, that has sidewalks going from the borough into West Goshen to the plaza, and that actually is the missing link for that sidewalk situation. On the other side of Garfield Avenue, we had sidewalks in there up to the plaza, up from right in front of the Garfield lane and down to the Pep Boys. That's where we're missing the sidewalks.
Yeah, both stretches need a sidewalk, right, from the Pep Boys to Garfield, and then from Garfield to the next property there, the storage location unit. Both, there's two sections of sidewalk needed for this project to be completed. So the only question I had or request was that in reviewing, the proposed budget is $5,950 to prepare the sketch plan and provide the estimate of cost. I would ask the Carroll Engineering's cost estimate break it down into both a combined project if everything can be done at once, or separate estimates for both below Garfield Avenue and above Garfield Avenue, because those are two separate property owners which may or may not ultimately decide to work with us on doing this project. So I'd like to see 3 cost estimates. Any other questions from the board? No. Okay, is a board member willing to make a motion to approve Carroll Engineering to prepare the scope work and the cost estimates for the proposed budget amount not to exceed $5,950?
So moved.
Thank you, John. Is there a second?
Second.
Thank you, Nate. Any board questions or comments on the motion?
Brian.
I have a couple of things that I've discussed with Chris. I have a couple of things that I've discussed with Chris Peterson in regard to this intersection. If you notice, the corner here is damaged, highly damaged from truck movements. They've pretty much carved out the corner. One of the things Chris and I talked about was because of the safety project that PennDOT has undertaken, where they've reduced Gay Street here from 2 lanes to 1 and made a very wide shoulder. One potential option would be to put in a delineated white lane and a pedestrian walking lane that is striped and delineated with delineators, because you have the wide shoulder and not actually have to construct a sidewalk. You should have a sidewalk against the curb line with the painted bike lane, and then you'd have the delineators on the outside of the bike lane, white reflective delineators. And that all would still be within the shoulder outside the travel lane. And that would eliminate the need for obtaining right of way, the need for the retaining walls in the corner here, because you got to open this corner up to get this open and safe. You're probably going to have to move this pole to make it work. And then the other option, the other potential, because of this grade, and we don't know where it is, there may be the requirement to necessarily even move grave sites that may have to be relocated in order to put the sidewalk along that face of the cemetery. So
that sounds good, but what about this actual intersection here? How do you get a sidewalk across that area if you...
PennDOT is most likely, if we do this, we're going to make us put a paved, we're going to put a concrete island there that's an area of refuge.
If those tractor trailers are there, the ones who are making all the damage on that corner, would they be able to make that turn then?
We'd have to open this, and that's going to make us improve this intersection to open that quarter up so it doesn't
Not
happen.
there.
So that's a whole nother level of adding cost and complexity to the project. So that was something that Chris and I talked about as a potential to look at, was the painted and delineated.
And when you say delineators, you mean like those plastic like bollard things?
The reflective bollards, yes. You see it in the city a lot, and I think there's also some in the borough where there's.
We actually probably, I think it's similar to what's out on Westchester Pike near Spring Road, I believe.
But there's areas in, you can see it, especially I've seen it in Philly, where they have like a bike lane, and then it's delineated with those of the bike to separate from traffic. There's enough room here, we may go get a bike lane and a pedestrian lane in there. And then the delineators on the outside, the bike lane and then pedestrian against, where they're, yes, they're walking on the pavement, but they're walking behind the bike lane and behind the delineators.
Some of your damage at that intersection is from car accidents as well.
You responded to them then?
He responded.
We
responded to them then?
So the way the road's configured, when you come around Westchester Pike on the turn,
Yeah.
come over the bridge, some cars there and with the merge, particularly before the concrete barrier between the lanes, they would come around and that was an impact on there.
I think it's one of the highest accident areas in the state, from what I've heard.
It's a larger area of the road, not necessarily just there, but just the way that it's just been designed forever. There's always going to be a
That's
certain.
another reason also to consider this too, is if we go to PennDOT for a permit, and there's a substantial accident history there, they may make us do a lot more work to the area than you're anticipating for just a sidewalk.
So with all that said, how do we determine whether we want to proceed with this actual scope as is, pay $5,950 with all these what ifs and could be's, and you've got to start from scratch issues?
Until you, so the proposal in front of you is to do a sketch of the sidewalk and what they think it would take to build a sidewalk, to install a sidewalk, what it would look like. Yeah. Until you actually have a formal scoping meeting with PennDOT about the project, and PennDOT agrees to the scope and what it is, and you start getting into what the HOP details are, we don't know what PennDOT's going to require.
So you're suggesting we should have that meeting first with PennDOT?
I am not going to, that's beyond my expertise about dealing with PennDOT. That's why we have traffic engineers, and I haven't dealt with PennDOT for that. Once you open the can with PennDOT, you can't close it.
Well, it's a can that needs to be opened up. I mean, there's an issue.
What do you
here
mean by
we
that?
need to
I
address.
mean, when you open, if you decide you're not going to work the project, you close
If
it
you're not for the
up.
project, you know before, but once we start saying we're going to do this project, that can is open, then we have to do whatever they put in.
But you'd have to do that anyway.
Yes.
Yeah.
So.
But there's a difference between spending $6,000 on a study, coming back with a sidewalk design, that let's say, I'm just making a number up, it's $750,000, and we say we want to apply for a grant for that, because of all this process and time. And then when we engage PennDOT at a certain point and say, oh no, that's not going to work, what you need to do is this, and we wasted money up front, we wasted time with the grant application, or whatever else. How do we obviate that problem?
So what I would suggest is we without having the sketch, we can't even take it to PennDOT.
Okay.
The sketch is what you can take to PennDOT with Carl take to PennDOT to start the scoping of the project. Yeah. And at that point, then you can say, once you get through PennDOT scoping, because there'll be multiple units at PennDOT that will weigh in on the scoping.
Okay.
And you see what comes out of it, and then from there you can decide if it's worthwhile to continue down the road to get far enough along to apply for grant funding, or is this going to be just something that becomes such an animal, or such that it's beyond what you feel comfortable tackling as a township? Okay. Now,
So
as far
in that
as
case-
timing goes, I can't tell you how long it takes to get the meeting. I've never been involved in one of those.
At that point, we'll have sunk this $6,000 into this study, and we don't know the outcome with any conversation with PennDOT. That's fair enough, but that's
At
the
least it
point
gets
where
us
we're going
started.
to get started.
I would suggest doing the sketch plan so you have something to
No,
present to
exactly.
PennDOT.
Makes sense.
And also to the landowners as well.
Yeah, I would start with PennDOT before the landowners, because PennDOT could change the scope to where you need more from the landowners. PennDOT may want you to move the sidewalk off further off the road, they may want you to widen it. PennDOT is the wild card
Okay,
in this. I would deal with PennDOT before I deal with the property owners individually.
very good. So I think we had a motion and a second, right? So let me open it up for public comment about this particular idea. Any comments? Doug, you want to comment? Do you mind coming up? I'm sorry. I'm trying to have a discipline here.
Need the exercise.
Doug White, West Goshen. Does 6,000, almost 6,000 seem reasonable for a sketch plan? How long does that take, or? I mean,
So it includes a survey scope, so topographic survey of the highlighted area, establish right of way, defined, prepare a survey base plan using downloaded point data to create the surface of the whole survey. The sketch plan scope will have an existing features plan prepared as a basis. It'll have the sidewalk sketch plan, considering the cemetery impact, steep slopes, potential Garfield Avenue intersection we talked about, utility pole relocation requirement, ADA ramp needs, stormwater management requirements for such a project, and potential easements that may be necessary. It will include the typical details in terms of the sidewalk design, curb, retaining wall, ADA ramps, retaining wall sketch, summary letter summarizing the design considerations, permit implications, and a preliminary opinion of probable costs that we talked about. So that was $3,700 plus the $2,250 for the survey, gives you the 5,900.
So how?
Sounds reasonable to me. Too.
Sounds reasonable, yeah.
Yeah.
Yeah. How many linear feet would be?
I want to say it's about 560 feet, I believe.
530.
530.
So you're thinking that it's okay to go ahead and spend this because you're going to eventually do something there?
Well, Brian, I think it's really useful. Could you go to an overhead view, plan view, just show how far the sidewalk does come down Paoli Pike today and where it's coming up from the borough? So you can see it. You can see the sidewalk there that terminates there.
Okay.
So we're talking about extending it from there to Garfield, and then from Garfield down to Pet Boys, where it picks up again with sidewalks there. So it is a missing link, if you like, in the walkability along this street.
Yeah, right.
I mean, there's huge safety concerns, as we've discussed, but we need PennDOT and others to weigh in on all that.
So in front of the self-storage, there's a sidewalk there?
Yes.
Yeah.
Okay, and it ends just past there?
It keeps going up there, look, to cross almost all the way.
It ends at the loop road.
Okay, so
Just recall that as part of our multimodal application for Montgomery Avenue, there's going to be sidewalk installation on the west side of Montgomery Avenue, so it'll connect that intersection as well.
So I guess the bottom line is, Brian's saying there's all these what ifs, but you're going to do something there anyway.
We'd like to do something. So to John's point, unless you get started, we never get anywhere, right? So we do something. It allows a conversation with PennDOT. PennDOT weighs in and says, no, we don't like your design, we want you to do this, and we can then start talking about, well, how much is that going to cost? What's the way to approach it at that point?
Okay, and you're anticipating there'll be grant funding?
Well, absolutely. I mean, there's all these PennDOT grant programs.
Okay.
I mean, I'm not saying we're going to get it, but until you've got something you can submit, you don't have anything.
Okay.
Truthfully, the most viable grant program for an option for a project of this type would be the local share account program, which has a cap of $1 million.
Okay, so you think the cost is justified? You think, in your opinion, cost is justified, and it's.
Well, I'd like to know what this is going to cost, and spending $6,000 to get a good assessment as to what a sidewalk would cost you is a good start.
So the process, just for some, I know it's been a while now, the process that the board's discussing with this project is virtually identical to what we did for the Rosedale Avenue.
Okay, all right. Okay, thanks.
Thank you, Doug. Any other questions? Okay, so Steve, sorry.
I just want to mention that I think this is a really good health and safety issue for the township. We've already discussed that. People walk along there, and it's very dangerous. And I think this is a good start. It shows PennDOT that we're serious about doing something on the structure with it.
Thanks, Steve. Any other comments? Okay, so we have a motion, I believe, right?
Yes, motion and a second, Mr. Chairman.
All right, so ready to take a vote. All in favor say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. Okay, agenda item number 13 is Discussion and possible approval of a supplemental proposal from consultant Roseanne McGrath for updates to the West Goshen Township's compensation and classification system policy. Chris.
Mr. Chairman, before the board this evening is consideration of a supplemental proposal from Roseanne McGrath Consulting for updates to the township's compensation and classification system. February 4th, 2024 meeting, the board approved an initial proposal for Ms. McGrath with a limit of 25 hours of work. She completed an initial analysis of the current structure and provided recommendations on next steps, which will be setting appropriate ranges and classifications. As previously noted, this would also include a performance management component. Since this would supplement the initial proposal that was approved, essentially a similar scope of work, I just asked Ms. McGrath to provide an estimate on the number of hours to complete the work. Her estimate was 10 to 20 hours, which would correspond to a fee range of $1,500 to $3,000 based on a rate of $150 per hour.
Thank you, Chris. Questions from the board? So, Ms. McGrath has done a piece of work for us earlier this year. She presented some analysis, some observations, and some conclusions. She had some suggested recommendations that the board digested, and so this is a work in progress. We believe there's some further work necessary to finalize what might be an update to the compensation, classification, etc. categories. And this is intended to conclude that with her expertise.
That's correct.
Very good. Any other questions or comments from the board? Okay, I'll make a motion to authorize consultant engagement with Ms. McGrath for amount not to exceed $3,000. Thank you. Is there any comments from the board or questions? Any public comments or questions? Very good. We'll take a vote. All in favor say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. Agenda item 14 is approval of the Board of Supervisors meeting minutes from November the 6th.
Mr. Chairman, I will note that I did receive some typo corrections from Mr. Woolman, and I have made all of those corrections.
Thank you. Does the board have any questions or comments on the minutes? Okay. I will make a motion to approve the meeting minutes from November the 6th, incorporating Mr. Woolman's typo corrections. Is there a second?
Second.
Thank you, Nate. Is there any public comments or questions? Okay, we'll take a vote. All in favor say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. Agenda item 15 is approval of the bills to be paid for the general fund, the sewer revenue fund, the waste and recycling fund, and the capital reserve fund. Are there any questions from the board on the bills list? Okay, is a board member willing to make a motion to approve the bills to be paid this evening?
I'll make the motion.
Thank you. Is there a second? Tina, is there any public comment or questions on the bills to be paid from these funds? Okay, we'll take a vote. All in favor say aye. Aye. Is there any opposition? Hearing none, the motion passes 4-0. I'll make a motion to adjourn the meeting at 7:58. Is there a second?
Second.
Thank you. All in favor of adjournment say aye. Aye. Thank you, everybody. The meeting is adjourned.